Are you wondering what Florida probate means and how it works? Hi, I'm Kellen Bryant, a Florida Bar Board Certified Elder Law Attorney, and I have been responsible for over 450 probate cases in the last 15 years. We help tight-knit families through a smooth probate process. I'm going to show you how we do it. So in the next 5 minutes, I'll simplify the probate process for you so you'll know exactly what to expect and how to prepare. Let's get into it. First off, what is probate? Probate's the legal process to handle somebody's assets after they pass away. The person who passed away is called the decedent. The person in charge of handling those assets is called the personal representative. In other states, it's called the executor. So what assets go through probate? Only the assets in the decedent's name when the decedent passed away. So that means assets that have a joint owner or beneficiary or held in a trust. Those assets do not go through probate. Now that we know we have to go through probate, what do we do? So the probate's going to generally be broken down in 4 phases. Phase 1 is to get appointed as personal representative. Now, the person in the will is generally named personal representative, and they're the one looking for the attorney to help them, guide them through this process. If there is nobody in the will, or there is no will, then the beneficiaries will select that person to guide through the probate process. The probate process is a court overlay of the things that have to be done to settle somebody's estate and get the money to the rightful beneficiaries. Now, the rightful beneficiaries is usually a family, but if there is no family, it could become the state of Florida if nothing is done. That term is called escheat. So if you do not do this job after a certain amount of years, 5 in Florida, the money could go to the state of Florida. So once that personal representative is appointed by the court is going to issue the personal representative something called letters of administration. That is just like a power of attorney, and that will allow the personal representative to do all the things to manage the decedent's affairs and the estate's affairs through the remaining 3 steps. So now let's get into step 2, which is the creditor and inventory process. So the personal representative, immediately when being appointed, should file notice through their attorney in the newspaper in the county where the decedent passed away. The personal representative should also be mailing that notice to creditors to anybody who has sent a bill to the decedent. And what that'll do is cut off people trying to go into the estate and get claims of money. Next, the personal representative is going to take those letters of administration, it's also called letters testamentary, or just letters, to all the banks and financial institutions that was just in the decedent's name. And what the personal representative is going to do is get the values of those accounts on the date of death for the beneficiaries and the IRS. Now, the personal representative also going to notice that the IRS that their loved one has passed away, along with the beneficiaries. Next is phase 3, and that's the gathering assets and the distribution and deciding where the assets should go legally. So during the collection process, in the discovery process, it's generally a 3 to 4 month process, and that is called the creditor claim process. And after that process is completed with the creditor claims, there should be no creditor claims, and by that time, the personal representative should have a handle on what needs to be distributed. Now, once all the assets are in front, the personal representative, with the help of an attorney, is going to look at the will, going to be communicating with all the beneficiaries, and the personal representative is going to say, here's the money we got, here's what I did with it, and here's what you're entitled to. Creditors get paid first, then beneficiaries under the will. And if everyone looks at this plan of distribution, this accounting says, hey, this sounds good, then phase 3 is going to go smoothly, and that's going to move us into the final stage, stage 4. And what the attorney and personal representative do is they look back and they say, are all the taxes paid? That's going to be the decedent's final income tax return. That's going to be the estate's income tax return. Do we have enough money held back to cover any kind of tax liabilities? For larger estates, it's going to be an estate tax return as well. And then the personal representative and the attorney say, hey, judge, court system, everybody got their money. They say it's cool. IRS got their money. They say it's cool. The creditors who said they were owed money, here's the satisfaction that they got their claim paid. Beneficiaries, they say they got their money. Here's a receipt that they got their share. If the judge says, yes, you did complete all the steps, and then you are done. And that's the end of the closeout phase, stage 4. So that's a run through of Florida probate in 5 minutes. If you're looking to avoid this process, you want to watch my next video, which is how to avoid probate.